Hello, my name is Nevas Mumba. I consider the judgment given by Judge Chirwa in the case between Professor Clive Chirwa and Zambia Railways as a landmark ruling. It sets a precedent which could salvage our nation from continued abuse of taxpayers' money by those who hold political office. The judgment confirms that late President Michael Sata, may his soul rest in peace, did not follow laid-down procedure in terminating Mr. Chirwa's contract. This unconstitutional act by a sitting president has cost Zambia's depleted treasury millions of kwacha. As painful as this judgment is to the taxpayer, it raises legitimate concerns that must be addressed. Why should the taxpayer be paying for politically motivated actions of a sitting president? It has become standard procedure for presidents both in Zambia and most of Africa to use political office to fix opponents or those perceived to be connected to political opponents without any regard to constitutional provisions. This has been happening under almost all presidents since independence. In most cases, once such vindictive behavior has been demonstrated, the powers that be go further and manipulate and influence the fragile judiciary to rule in the favor of a sitting president. In the case under discussion, with the former president having passed away, it gives us an opportunity to correct the wrongs that continue to deplete our national resources. It is a known fact that under the late president, numerous political and vindictive decisions were made which have cost government millions of kwacha. Amongst many, we may factor in the unilateral decision of the former president to cancel the Zamtel deal without following procedure. I'm not saying that the Zamtel deal was done in the right spirit. I'm talking about procedure. Zambia was asked to pay as a result $382 million for abrogating contractual obligations. To my knowledge, it still remains unpaid. Other politically motivated actions included the instant, wholesome retirement of all district commissioners and the recalling of almost all diplomatic heads of missions at the same time when the Patriotic Front under Mr. Michael Sata came into office. I must mention that to recall one ambassador and prepare to send another is an expensive venture which must be done only when there is absolute need and funding. This is outside individual political decisions, including the decision to charge me with abuse of office while I served as High Commissioner in Canada. This decision was made when it was announced that I would return to Zambia to contest the presidency of the Movement for Multi-Party Democracy. Millions of kwacha were spent to sending 2 sets of auditors to Canada and managing a 7-year-long trial, which continued long after President Michael Sata had died, only to end up in an absolute discharge after it was confirmed that I neither handled nor mismanaged public funds. But this was all done to stop an individual from participating in the political process by using the instruments of government and institutions of government to further political agendas. The question that begs to be answered is, why should the Zambian taxpayer carry the cost of these personal, politically motivated actions by a sitting president? I must state that while the intention might be good and politically correct, it is vital that the Attorney General advises the head of state of any ramifications of matters based on contractual agreements. I am a Pan-Africanist. I am against selling our assets to foreigners. I believe that we must own our assets. If we are going to need any foreign investments, we must be heavy on bringing in that expertise that will help us do our job better, but not to give up our assets. However, once these contracts have been signed and a new government comes in and wants to reverse that decision, they must make sure they have looked at every detail and every sentence in that contract so that they will not cost the nation and the taxpayer unnecessary amounts of money. I'm now sitting on edge concerning the steps that government has taken against Mopani copper mines, Konkola copper mines, and in recent days, Copperbelt Energy Company. If no due diligence has been done by government, and if the decisions are knee-jerk decisions, the taxpayer must prepare or start to prepare for more payouts in legal costs. We, however, salute Judge Chirwa for her courage in delivering such a monumental judgment, which one hopes could change the quality of the office of President. I suggest that Parliament deals with this anomaly by providing legislation which compels the courts to demand that such fees or costs are compensated from the personal estate of the President concerned. To maintain the status quo would be to cheapen the dignity of the presidency and place an unnecessary burden on the shoulders of a taxpayer. I thank you, and may God bless our great nation.